Hi everyone, my name is Tanea and I am here with Abort Ignorance Montana. If you haven't heard of Abort Ignorance Montana yet, we are a platform that is dedicated to sharing easy to understand information about what abortion is and what Montana's abortion laws currently are. So we've been talking about CA 128 in the recent weeks. Feel free to check out those videos. It's a constitutional initiative that's coming forward that will change our constitution in Montana to actually include access to abortion directly in that constitution. So today we're going to talk a little bit about the history of abortion laws in Montana, just to help us understand, do we really need this initiative or not? So abortion laws in Montana really date back to 25 years ago. In 1999, I have this little history cheat sheet that I've made. If you want one of these, I can get you one. This is what I'm going to be using today to explain the history of abortion laws. So in 1999, there was a court case called Armstrong versus State, and they were basically battling over, does a right to privacy include the right to have an abortion? And you can go and find the briefs on that case and read as much of the text as you want, but I can tell you, again, this is easy to understand information. So what you need to know from Armstrong versus State in 1999 is that the Montana Supreme Court at that point, 25 years ago, affirmed that all Montanans have the right to an abortion under the right to privacy in our state. So in our state constitution, there is an explicit right to privacy, and us Montanans love our right to privacy. We all do. I love it. I'm sure you love it, and we want that protected. And that's already in our state constitution. And the Montana Supreme Court 25 years ago determined that a right to an abortion includes the right to privacy. And that has been upheld ever since. There has been decades of abortion legislation that has come through that would be on the pro-life side, trying to limit those regulations. And it always ends up back in the Montana Supreme Court. And they always end up saying, once again, Montanans have the right to privacy, and that includes the right to an abortion. And so just to give you some more history of that, the first time that it was really contested after 1999, when that decision was first made, that Montanans have the right to abortion under the right to privacy. In 2013, there was a Parental Notice Act that went through and was actually voted on. And that actually passed. And what that was parents would be required, or medical professionals would be required to notify parents when their minor child sought an abortion. And that passed. Montanans thought like, yeah, that seems reasonable. Parents should be notified. Let's pass that. And then there were some people that came in, I believe it was Planned Parenthood, and they decided like, hey, we have a right to privacy in Montana, and this is infringing on that right. So that actually they sued that law, and that actually went to Montana Supreme Court, and they just recently, that was in 2013, they just recently heard that case, and Montana Supreme Court decided that that's unconstitutional to have to notify parents of their minor child seeking an abortion. And so that is one case, the first instance. It took lots of years to come through, but in 2013, that was the first time that someone raised their flag and said, hey, this limitation on abortion that you're trying to bring forth by requiring parental notification is actually unconstitutional. And the Montana Supreme Court said, yeah, that's unconstitutional because we decided in 1999 that all Montanans have the right to an abortion under the right to privacy in Montana. That's just the first instance of that. Then later in 2021, things started to really heat up. So that's, years, decades after 1999. And there started to finally come forth a lot of legislation and laws that were trying to limit the access to abortion, not deny the right altogether, but just put some limitations on it. So some examples of those are in 2021, there was it was called House Bill 136, and it was a Pain-Capable Unborn Child Protection Act. And so what that would have done, had that passed, is that would have prevented abortions after 20 weeks, because we know scientifically that babies in the womb can feel pain starting at least 20 weeks of gestational age of the pregnancy. And so this law, which was passed in our legislation in 2021 and was supposed to be enacted, meaning that nowhere in Montana would anybody be able to access an abortion after 20 weeks. That went through legally. But then again, it was sued. And what happens when someone sues a law, the legislation puts forth and votes on and says, yes, we want this to be a new law in Montana. Then someone sues that, and then it's something called enjoined. So enjoined means that you can't enforce it because it's currently in legal litigation, and we have to find out, is this law, the legislation passed, is it actually constitutional? And so that happened to this Pain Capable Unborn Child Protection Act, and it was enjoined in 2021. And the same thing happened with, there was other laws in 2021. One was the provision of information. And so that would have required that all patients have to have an ultrasound before they can agree to have an abortion. And that also was sued and it was enjoined. And these are still laws that are held up in the courts. So they're unenforceable because our Supreme Court is going back and deciding, do these laws infringe on Montanans' right to an abortion that we said they had starting in 1999? And so none of these are enforceable because they are contested. There was another one that was going to require informed consent and reporting on the abortion pill. Again, that was just a law that was passed that was meant to do some regulations on abortion, and specifically the abortion pill. That's really easy to access and it can have some very serious side effects. And so our legislators said, hey, we think we should regulate this. We regulate every other drug, and we have to, have required reportings on them. And so let's do that for this drug as well. And again, it was sued and enjoined, which means that it's still waiting to be heard in the Montana Supreme Court to determine, is this constitutional or not? So as you can see, there's a theme, and we keep coming back to any law that is passed about abortion in Montana, and it becomes enjoined, it gets sued, and the Montana Supreme Court then has to determine, is that law constitutional or not? And when these cases are being heard, most often, I haven't heard of a single one where the Montana Supreme Court has said that it is constitutional. Like, it's okay to put this limitation on abortion. They always have said, no, Montanans have a right to an abortion. So that is a really affirmed right that we have in our state, even though there's been so many laws that have come forth. In 2022, there was 2 more that came through. Actually, no, there was 5, 6, there was at least 6 that came through that were putting regulations on abortion. And one of them I was actually voted on by Montanans, and they voted it down. They said, no, we don't want that in Montana. We have a right to abortion. And then there was 5 other laws that were passed by the legislative session, which when that happens, those people are representing their constituents. So they're actually representing large portions of Montanans that probably would say we should have some regulations on abortion, and they are in favor of that. But then it keeps coming back to the question of, but is it constitutional? And the Supreme Court, once it gets sued, that law gets sued, the Supreme Court gets to decide that, not our representatives in our state. So that happened again in 2022. And then in 2023, there was another handful of laws that were passed. It was at least 10, if not 11 laws that were passed that would have limited abortion access. It wouldn't have taken it away. It just would have done things like we've already talked about, like put regulations on the abortion clinics or on the abortion pill, which are all things that are required in every other area of medicine. And so all of those passed, and all of that is representing a large portion of Montanans saying, yes, we elected this legislator to go speak for us at the legislative session legally in our state to say, this is what we do want in Montana, and this is what we don't want in Montana. And so what Montanans are saying through the legislative process, by electing their officials that represent them, Montanans are saying, we would like some regulations on abortions in Montana. And then what keeps happening is other people that say, no, we have this affirmed right. They're suing these laws, they're getting enjoined, and then most often they're getting affirmed by the Supreme Court to say, we don't need these regulations in Montana because Armstrong versus State in 1999 declared that Montanans have a right to an abortion. It's part of their right to privacy. So I hope that some of that makes sense to you. In essence, there has been 25 years of abortion access in Montana that has been affirmed as we do have that right under the right to privacy. And there's been 25 years of legislators coming forward representing their constituents in Montana, people like you and me, representing us. We elect them. And they've been saying Montanans may want, that right to privacy to include a right to an abortion, but Montanans also want some regulations on this. And it keeps getting contested and coming back to that's unconstitutional. We can't put any regulations on abortion. And so I'm sharing all of that in this video, hoping to make the point to all of you, to myself, to us, that we already have a full right to abortion in Montana. It is affirmed again and again, as you can see by this little history timeline, and hopefully some of the legal mumbo jumbo that I've explained, that we have a right to an abortion in Montana because of Armstrong versus State. Armstrong versus State is essentially Montana's Roe v. Wade. So when Roe v. Wade was overturned, then it went back to the states, and states get to decide. And Montana already decided in 1999, we want our own version of Roe v. Wade. And so that is currently in place in Montana. So if CI 128, which is the constitutional initiative that's going to expand abortion access, it's a very vague initiative, and it expands abortion access up to 9 months of pregnancy. If we vote yes on that, we're going beyond Montana's version of Roe v. Wade with that right to privacy. And we're saying we want late-term abortion. We're saying we want no parent to have to be involved ever with their minor child's abortion decision. We want, it's okay with us if sex traffickers or sexual predators, assault a girl and she becomes pregnant and they take her to get an abortion, no questions asked. We're okay with that. That's what CI 128 is saying. It's saying that we don't just want a right to privacy in Montana to include a right to an abortion. We actually want expanded access. We want up to the point of birth. We want taxpayer-funded abortions. We want all of these things, and that's what it's saying. And so if you don't agree with that, then I would really urge you to learn more about CI 128. And if you don't have the time, maybe this is enough information for you, I just urge you to vote no on CI 128. None of this will change. None of the Armstrong versus State, abortion, including a right to abortion rights under a right to privacy in Montana, none of that will change. All of that will stay the same. If you vote no on CI 128, you'll just be awarding the expanded version of abortion access that most Montanans would say is too extreme for us. So I urge you to vote no on CI 128. You're not going to be hurting women. You're actually going to be saving women. And I would encourage you to do that in November. If you have any questions about it, if you want some more history of abortion, what these laws were that have passed in these different eras of abortion laws in Montana, we can talk about those and where each one currently is at. Most of them are just enjoined in the courts, so they're still waiting to be heard, which means they're unenforceable. And so if you have any questions about that, you can reach out to abortignorancemt@gmail.com or abortignorancemt.com. And I'd love to talk with you about that and answer any questions that you have. So until next time, see you guys.